We can't make somebody redundant, right, when they're pregnant or on maternity leave? Well, not quite true, but the protection is being extended this year with the maternity leave, adoption leave and shared parental leave regulations 2024 expected to come into force in April. In this video, I'm going to tell you exactly what this means for business. My name is Jenefer, I'm the founder of Silk Helix, and we help businesses with all things people management through training and HR advice, underpinned with making sure that you remain compliant with employment law, but most importantly, you're getting the best out of your people. So let's explain what these regulations really mean and what the deal really is when it comes to redundancy during pregnancy, maternity, or even adoption leave and shared parental leave. So what does this all really mean? Well, firstly, the Equality Act 2010 prevents us from treating somebody less favourably because of pregnancy or maternity. We also can't treat somebody less favourably and certainly can't dismiss somebody for asserting a statutory right, which would include things like taking time off for adoption leave or shared parental leave. So we can't dismiss somebody purely because they have taken one of these periods of leave or because they are pregnant. This isn't changing, no signs that's going to change, and what the redundancy protections does is puts some additional protection on top of that. And that's been in place for a while now. And what that means is that if somebody is made redundant, i.e. their role is made redundant, because redundancy is never an individual, it's always their role. So if somebody's role is made redundant whilst they are pregnant or on maternity leave, then we are expected to find suitable alternative employment and offer it to them where it exists. This means that they do get that kind of first refusal at that. If somebody's on maternity leave, we would actually hold off their dismissal to the end of the maternity leave. So even if there's not suitable alternative employment right now, it might come up before the end of the maternity leave. What the new regulations mean is that the protection from redundancy and the right to be offered suitable alternative employment extends to a full 18 months following the either expected week of childbirth or, if we know it, the date of birth of the child. That means that they will still have protection when they return from maternity leave. So it's just extending the protections that we've already got. It's not preventing redundancy. We've now got these protections in place for longer than a 2-year period. If you put together the pregnancy plus the period of 18 months, that's over 2 years. A lot can happen in business in that time, and employers aren't entirely prevented from redundancies. So if a department closes, for example, if the way the business is going changes and those roles are no longer needed, you can still make redundancies as long as that redundancy is not because of the pregnancy, it's just something that would have happened otherwise. We can still make those redundancies. What we do have to do is look at, is there suitable alternative employment? Now, we often work with small employers where suitable alternative employment just doesn't exist. If we're making redundancies, we don't have something else to offer. But that's not always the case. Often there is something else to offer. There is suitable alternative, and particularly in large organisations, or if we're downsizing, let's say we're taking a team from 10 to 5, we're still going to have roles within that team that's likely to be suitable alternative employment. So we are going to have to make sure that we're offering that first to anybody who is pregnant, on maternity leave, on adoption leave, on shared parental leave, or within that protection period. So that's all it means. It doesn't mean that businesses can't make the decisions that they need to. It doesn't mean that we can't make somebody redundant if we have to. If it's not because of the pregnancy, it is for a genuine business reason, and there is not suitable alternative employment to offer. But we do have to make sure we've considered that. And that means really for employers, we'd be saying, take advice. I mean, in any dismissal redundancy situation, I'd recommend taking advice, because even if you've got that strong, genuine business reason, you need to make sure you followed a fair process in order to avoid unfair dismissal claims. Even more so when it comes to pregnancy and maternity, making sure we've not got sex discrimination claims in there, or pregnancy and maternity discrimination claims in there. We have to make sure we're protected from all of those things. But we can do that. We can do the things that we need to. It's just making sure that we've followed the right processes. We have treated people fairly, and actually because of these redundancy protections, that we have looked at whether there's suitable alternative employment that we can offer. And it is these situations that can make employment law really complex for employers to keep up with and make sure you're getting things right, even when you are making the right decisions for your business. It's why we recommend advice, why we give advice. It's also why we have packages like our maternity support package, where there is lots of information taking you through the whole process, explaining how you do things, make sure you do things right, make sure you've got the right things happening at the right time to comply with employment law. So do check out the links in the description below on how to work with us, either for direct advice or for our digital support packages. And if you're finding these videos useful, there's quite a few employment law changes coming in 2024, and we will be making videos on all of them, keeping you up to date and ensuring you've got all of the information that you need to run your business effectively. So do hit that subscribe button and the notification bell so you don't miss a single video.